Hello and welcome to the Herrington Carmichael Employment Law Update for June 2018. My name is Alistair MacArthur. I'm the head of the employment team with Herrington Carmichael, and as always I have the 4 key topics for you in the last month in the world of employment law. So let's kick off with the issue of gender pay gap reporting. As many of you know, this came into place with the beginning of April, where reports had to be made. However, what we now know is the Equality and Human Rights Commission is starting to enforce. So if you had to make a gender pay gap report and you've not done so, the EHRC are now putting out correspondence to you and are looking at enforcement proceedings. So if you're receiving that, do take it seriously, and if you haven't reported, do report. What you'll need to do in coming years is obviously to keep a track of the number of employees you have, and if you hit that 250 threshold, be looking to report in good time. Let's move on to some cases, and let's start with the case of Hinks and Sense Network Limited. This case related to references, and Mr. Hinks was very upset about a reference that was given that referred to previous investigations. Now, as an employer, you would know that in most cases you should only give factual references, but in this case the employer decided to go further and give information of an investigation process. What was held was there was nothing wrong with doing that, provided that it was given in good faith, and there weren't any flags of bad faith in relation to the investigation process. In this case that was fine. However, I would still be advising you very carefully to only give factual references. It avoids the need for litigation. Simple. Next, bumping in redundancies. Let's talk about the case of Mirab and Mentor Graphics UK Limited. This is not new law. In a redundancy situation, an employer has to consider the issue of bumping. That's where you take a senior employee and bump them into a junior role and make the junior employee redundant. It's got nothing to do with Mr. Men. However, in this case of Mirab, they had to go back and had to consider this issue, and the Employment Appeal Tribunal re-emphasised the need to consider bumping. An employer therefore has to look at bumping and consider it. It does not have to bump. So it's a consideration fact. So in a redundancy situation where you're dealing with senior employees, do look at the issue of bumping. Final case here today is the case of City of York Council and Grosset. In this case, Mr. Grosset was disciplined in relation to showing videos to adolescents. He claimed that he had done this as a consequence of stress caused by the exacerbation of his condition, being cystic fibrosis. The employer didn't look at this properly. They didn't consider it. They didn't go into looking at whether they had knowledge of the stress that would be caused to him, and this may have an effect on his conduct. They just didn't look at it. So what that means is effectively there was a bad investigation. Although there was a fair dismissal in this case, there was a finding of disability discrimination or unfavourable treatment on the basis of his condition. What does this leave us? If you're dealing with disciplining employees who are disabled, you need to be very, very careful, and you need to investigate it properly, look at the whole circumstances and consider whether their disability may have impacted on their conduct. It's an area where you may need to take some specialist advice. It's an area where there may need to be occupational health advice. Treat the employee carefully, tread carefully, and if you have knowledge of a disability, make sure you go that extra mile. That's it from me this month. I'll be back in July. Thank you.